The Chief Justice has been delayed slightly, so we're going to go ahead and call actually the disciplinary case next. And the Chief Justice will be joining us in just a few minutes after he completes the administrative matter he's having to deal with. At this time, I will call 119-909 in the matter of Timothy Grohl. Counsel?
May it please the court, Stan Haslett appearing for the Disciplinary Administrator's Office. I would like to reserve 2 minutes for rebuttal, please.
All right.
Yesterday, about noon, I filed a substitution of counsel motion. It was actually Penny Moylan of our office who handled this case at the trial level. Ms. Moylan has a family illness that she's attending to on the East Coast. This is an original action in attorney discipline. The hearing itself was held on June 5th of 2018. The respondent was present with counsel, John Ambrosio. The Disciplinary Administrator's Office, as I said, appeared by Penny Moylan. At the hearing and prior to the hearing, the respondent stipulated to factual findings and rule violations. And on August 24th of 2018, the final hearing report was filed. On September 5th of 2018, Mr. Ambrosio filed a notice that he did not intend to take any exceptions to the findings of fact made by the panel. On April 10th of 2018, Ms. Moylan had filed a 2-count formal complaint. In the first case, the respondent was appointed to represent a criminal defendant because of a denial of his KSA 60-1507 motion. The panel found that the respondent admitted the following violations. That he violated Rule 1.1 on competence for his failure to request a Van Cleve hearing on the issue of ineffective assistance of counsel. KRPC 1.3 diligence for his failure to timely notify his client of the Court of Appeals decision. The rule on communication 1.4 because of the respondent's failure to respond to 2 letters he received from his client asking about the status of his case. And KRPC 1.16, which deals with termination of representation, that rule was violated because when he failed to withdraw and protect the interests of his client after the Court of Appeals decision came down. No action was taken by the respondent after the Court of Appeals decision came down. In fact, I don't think the client found out until just shortly before the time would run for him to seek further relief. So there was certainly that potential for harm. In the second case, on November 3rd of 2015, the respondent filed a petition for issuance of letters of administration in Labette County. The respondent was appointed pursuant to the request as administrator of the estate. During his time as attorney and administrator of the estate, the respondent made 11 distributions to himself from the estate account for what he determined or what he said was attorney's fees. These distributions to himself in the amount of $45,000 were made without court approval. The court ordered an accounting. A court order in accounting was filed by the respondent in which he did not list the $45,000 which he had distributed to himself in the 11 separate distributions. The respondent, after being ordered by the court to file an accounting, did deposit $45,000 back into the estate account.
Counsel, let me stop you there because I had a question about the money going in and out. The $45,000 that went to reimburse the estate came out of his trust account. How did the money get in? What money went into the trust account in order for it to come out?
Well, the testimony was he borrowed money from his mother. It's a good point. I don't think there was any evidence as to why the money went into his trust account, but the money that he used.
Here's my question. Are you satisfied, or do the facts show that every dollar of the $45,000 that came out of the trust account to repay the estate was all his money and not some other money sitting in his trust account on behalf of another client?
There is no evidence to the contrary.
Okay.
I understand.
I understand the hedge.
I understand your concern, but I don't have any evidence that the money was not his mother's money, and I don't have any evidence that it came from any other source.
Or that there was a time delay or anything like that.
Right, correct. The complaint in this case was filed with a district court judge hearing the administration case. Rule violations were as follows: 1.5, the $45,000 fee was unreasonable. 1.15, that the respondent failed to properly safeguard the $45,000, which he shouldn't have had in his possession, and he failed to safeguard that property. 3.3A1, by filing accountings with the court, which did not include the 11 distributions to himself of $45,000. 8.4B, for committing what in essence is a criminal act. The respondent's acts rose to the level of a violation of KSA 21-5803, deprivation of property. 8.4C, dishonest conduct by taking the $45,000 without permission of the court. And 8.4D, conduct prejudicial to the administration of justice, for filing incomplete, inaccurate, and false accountings with the court. There were actually two. There was the initial one, and then there was an amended accounting. As far as the recommendation, 2 of the panel members recommended indefinite suspension. A 3rd member recommended a 2-year suspension with a reinstatement hearing. Of course, the indefinite suspension would require a reinstatement hearing. Our office recommended disbarment, and I want to explain the reason for our recommendation. Make a concession here that there are mitigating factors that were testified to about by the respondent. His father's illness and subsequent death. His son had a serious car accident. There is evidence that he suffered from depression, and there is evidence, obviously, that he made restitution. However, there were 3 very significant findings of misconduct. There was the misappropriation of funds, what constituted 11 really separate criminal acts by the respondent. In addition, there was a dishonesty to the court in the filing of the 2 accountings, really an attempt, obviously, to try to cover up what had occurred here. There is a whole separate case involving his representation of the criminal defendant, in which there was a very real potential of harm, lack of diligence, or lack of communication, lack of competence. In reading the transcript, I see where Mr. Ambrosio, in his closing, stressed the fact that the respondent made restitution. Mr. Ambrosio even said, this really ought to place this in a different category because he paid the money back. I want to point out that in the final hearing report itself, there were 4 cases decided by this court that the panel cited in support of its findings. They were Wright, Schnitger, Harrington, and Lundgren. In each of these cases, the respondent converted client funds. In each case, the respondent made some sort of restitution, in some cases, almost all of the restitution. And in each case, this court disbarred the respondent. In the Wright case, this court talked about the level of misconduct and the repeated episodes, because there had been a number of instances where the respondent had taken money from his great aunt. In the Schnitger case, this court referred to the serious felonious misconduct. As in this case, in that case, the final hearing report noted the fact that these acts constituted felony criminal activity. In the Harrington case, this court said substantial restitution, even full restitution, would not have negated the fact that the respondent converted his client's funds for his personal use, an ethical violation of the highest order. Further, this court said, this court has consistently repudiated the no harm, no foul argument in disciplinary cases. In the Lundgren case, this was a reciprocal case from Utah, but the respondent was disbarred in Utah. There had been restitution made, and this court disbarred Mr. Lundgren as well. this is not just a matter of conversion. I mean, we have the dishonesty of the court. We have the separate misconduct in the criminal case. I agree that there's mitigation, but in this case, the serious misconduct and the nature of this misconduct really trumps the mitigation in my estimation, and I think disbarment is the appropriate discipline.
Does that conclude your presentation?
Yes.
Do we have any questions? Thank you, counsel.
Sorry about that, John.
That's all. John Ambrosio on behalf of the respondent. May it please the court, Mr. Chief Justice. We agree with the findings of the panel in terms of the facts, the conclusions of law, and the violations. There's no doubt that this is an egregious case. We now concur, we are asking this court to indefinitely suspend the respondent in this case and give him a chance to come back after 3 years of that indefinite suspension. We understand that there'll have to be a hearing, and we have changed our recommendation that we made to the panel. In DA 12756, he did not handle the appeal correctly. There's no doubt. He dropped the ball. He was incompetent. He did not communicate with his client who was in prison. There's no doubt about that. For that, he apologized and he's sorry for. In DA 12931, there's no doubt that he had made the 11 distributions without court approval. And all he can say is that he's sorry for that. He was in a bad financial state at the time, which doesn't excuse him, and he shouldn't have taken the money. He should have applied to the court, obviously, for a fee, made a fee application. And we doubt very much the court would allow him to have had $45,000 for the work he had done. He was wrong. He took the money. He later returned it. To answer Justice Biles' questions, he borrowed the money from his mother, and he put it in his trust account. I have no explanation as to why he put it in his trust account, why he didn't put it back in the estate account, and I have no explanation as to why he left out on the accounting that he had taken money on 11 times to the tune of $45,000. We have no excuse for the conduct. All we are asking is because of what he was going through at the time, the accident to his son, the depression, the death of his dad, he wasn't thinking correctly. This doesn't excuse his behavior, but we're hopeful that after 3 years of indefinite suspension, he'll be able to prove that he's eligible to come back and practice law. This is a man who has worked in his community. He was a prosecutor. He did criminal defense work for most of his practice. If you read some of the letters, and I think the panel indicated, he made changes in some of the youth in his community. I think they should go on his side of the ledger. I think he should be given a chance. He doesn't excuse his own behavior. He's terribly embarrassed in his community. He got fired as a prosecutor, as well he should have been, after we had the panel hearing and some of the information came out. He'd like to address you if at all possible.
It's agreed.
What's your stuff here? It's web. That's it.
Okay. Let me begin by apologizing to this court for having to deal with this matter based upon my actions. Apologize to Mr. Hazlitt and Ms. Moylan of the Disciplinary Administrator's Office because of my actions resulting in them investing a substantial amount of time investigating it when they should probably have had better things to do. I want to apologize to my wife of 42 years for the financial situation that we were in, hiding it from her, or at least shielding her from it, which would have been better for her to know so that she could have assisted with it. Excuse me. I want to apologize to my 6 children, especially my son that's an attorney, because he'll have to deal with questions in regard to this. I want to apologize to my law school classmates for letting them down in regard to the high standards of ethical behavior that we were taught in law school. In regard to the punishment, after the panel hearing and even before the reports came down, I instructed Mr. Ambrosio to change our argument. I felt that the 1-year suspension that we argued for was not adequate based upon the seriousness of my actions. And I would like to briefly explain my actions. For some time in private practice, I'd been looking for some type of full-time employment. The stress of private practice, solo practice was difficult at times. And basically I jumped at the first chance that was available and began prosecuting cases in Crawford County. Pretty much immediately it was clear that position wasn't going to work out. I really didn't do due diligence. I had talked to one of the attorneys that was aware of the situation there, and she apologized later. She, in fact, testified on the hearing panel, Sarah Beasley, because she thought I was an experienced attorney and could deal with the issues that occurred. At that point in time, probably November, I was pretty much aware I was on my way out. We had agreed that I would retain this estate case, and I was suffering from depression at that point in time. Well, I had for some time, but was not doing a very good job dealing with it, even though I was taking medication and going to counseling. I started applying for jobs, rarely got an answer back. A few times I got turned down letters. At my age at that point in time, it was just not very favorable not very favorable. It was depressing, I guess I should say. So when I was actually let go in February, I pretty much panicked at that point in time. I decided to open private practice. Didn't make wise decisions. Instead of just renting a small office and hanging my shingle out, I decided to purchase on the cheap a building that had been an office building but hadn't been upkept in a long time. My days consisted at that point in time of practicing law in the morning for a few hours, like getting appointments or hearings done, going home, changing and remodeling my office, which took about 7 months to do and a lot more money than I had or thought I could expend on it. And that's had some basis in regard to withdrawal of the money. During that same period of time, like right after, I'd already scheduled vacation with the Crawford County Attorney's Office to go see my dad, who for his 81st birthday, because I'd been fighting with one of my sisters about getting them to relocate and regarding assets, which really shouldn't have been being discussed at that point in time. I had missed his 80th birthday. So I get fired in the middle of the week and canceled the weekend stay with my dad. His health went from bad to worse after that. And I was quite bitter about that whole situation. And he died in September. I don't remember the exact date, but during that period of time, my son, who was an attorney, was going to a baseball game or practice with my grandson, Mace. And their car was rear-ended, and he had a serious concussion. It took a long time for him to get better from that, and he basically was just not a real good situation. In May of 2016, I was hired by the Montgomery County Attorney's Office, and that job was going pretty smoothly until the hearing panel. Things got along well. Financial situation was looking much better, but then the hearing panel, and I was let go, and probably rightfully so, in regard to that because of the situation. In retrospect, I certainly shouldn't have panicked. Since June 6th, I've been looking for work, and it's been kind of difficult, but financially we've tightened the belt and things are a lot better. But, not perfect, obviously. Finally, in answer to the question about the money into the trust account, we provided copies of the deposit receipt. I think even a copy of the check that my mother had helped me with on that. I don't know why I rather than just deposit that check into the state account, I felt like it was not my money, so I deposited it in the trust account. Maybe not the wisest decision, but the money went straight to there and then straight into the state account. And I did, to be honest about it, struggle with the whole thing with the accounting. I should have been straightforward with it, should have self-reported. In fact, I came close a couple of times, but just didn't. Obviously, hindsight's 20/20, and I wish I had of. In regard to the depression, I'm still taking medication. I'm still seeing a counselor. Basically, at least my bottom line is I don't think this activity is typical of my personality. I was not raised that way. Would like some opportunity to, at some point, be reinstated and prove to you that this was kind of an aberration. This is not my personality, and that I don't go around doing those things. And if you do give me that opportunity, I promise I will not embarrass you by doing these kind of things again. Thank you.
Do we have any questions for either counsel? All right. Thank you both.
I would waive my rebuttal unless you have any questions of me.
Any questions? See none. Thank you both. Thank all three of you for your arguments this morning. Court will take this matter under advisement.